What's up, everybody? How y'all doing today, my good peoples? You know what I'm saying? I hope y'all taking care of y'allself today, you know what I'm saying? Y'all know what to do. Like, share, and comment. Smash that doorbell for me, baby, you heard me. And keep God first, baby, over everything. So, on the note, my good people, I'm gonna let this video take off. I'm gonna let's like catch you by the end, baby. Let's go.
Right back to the United States if they are facing the death penalty here. So the risk of flight with him is actually greater because it is going to be much more difficult to recover him should he leave the jurisdiction.
Y&W Melly's high-profile retrial is just
spent 6 years of his birthdays in that jail. The last 3 years that he's spent in that jail, he has been deprived of basic human needs, basically.
I'm Elizabeth Milner with Law and Crime. Jamel
Nor statute that says
charges of capital murder. The defense is still pushing for bond.
no law nor statute that says or rule that says we can't come back and argue for his release after a year and a half of what's been going on.
I agree with you. That's why we're here today.
It was a packed courtroom this week, mainly of Melly's family, when the Florida rapper appeared before a Broward County judge. And before the judge heard arguments about why Melly should or shouldn't be allowed the chance for bond, the judge heard from the lawyer of the victims' families first.
I think the victims, the family members, just wanted us to at least place an objection on the record, let their feelings be known. Of course, under Marcy's law, they have that right. And so we followed that objection just so Your Honor knows what their position is, what our position is here, that we would be, and the family members would be objecting to any release in this case.
The defense tried to call a witness to the stand to testify at Tuesday's hearing. It was Dr. Heather Holmes, a forensic psychologist, but the state wasn't about to let that happen.
We're going to be objecting to Dr. Holmes' testimony just because she was noticed in the state less than 36 hours ago. She's going to be testifying as an expert. We don't know what documents she was relying upon. We don't know what materials she was given to review. We've been provided no reports, nor do we know the substance of her testimony.
When was she listed as a witness?
She was listed, I believe, Friday evening after we had hired her. The state wants to take a 10-minute break. We can talk to her. There was no report.
She was listed
Sunday night.
Stop. Okay. You listed her Friday afternoon.
I believe so.
Okay.
Your Honor, I can tell you the court filing came in and it's on Odyssey from
Okay.
about Sunday evening.
So you don't want her testimony to be considered today in the evidence?
We're fine bifurcating once we, have enough time to know what she's going to testify to, know what she relied upon, have time to look into that. But today, with, as Mr. Griffith said, less than 36 hours, we're not at all prepared to have an expert testify.
Is she in fact testifying as an expert?
She is testifying as to basically the second portion of my motion, going to the appropriateness of the bond. So I am tendering her up there. She did sit with them. She has information to provide to the court.
She interviewed your client?
Yes,
And she's going to testify about that?
Yes, Judge.
And just so Your Honor's clear, the e-filing from the court, the clerk's portal came in at 10:31 p.m. on 5/4, which was Sunday evening.
Okay, so the state's objection is sustained. She's not going to testify today.
So a loss for the defense there, but the lawyers still need to do what they do and argue their reasoning.
The circuit court may exercise discretion to grant pre-trial release if the defendant can prove conditions of release. If the defendant can prove that his conditions of release can effectively protect the public from the risk of physical harm, assure his presence at trial, and protect the integrity of the court. There are some other factors that we get from other cases talking about flight. Is he a risk of flight? So going through that, what we would be proposing for Mr. Demons would be a minimal monetary bond with the condition that the defendant would remain at his new residence. The defendant would not have possession of a firearm. The defendant would wear the standard pre-trial ankle monitor, of course I will not call him, was a member of the security company who we have engaged to, one, it was twofold what I had asked for. Mr. Demons would have a 24-hour security guard on his person. There would be then 2 other security guards on the property to basically secure the premises of the property of the house and the house. They would be reporting if there was any infractions of Mr. Dimmons. They would be reporting directly to myself, the rest of the legal team, the state attorney, and to the court. You basically have your own deputy, paid deputy, with him. Mr. Dimmons is not a flight risk. He does not possess a passport. I don't even believe he has a driver's license at this time. We can assure his presence at trial. He's been here every hearing. He will be here every hearing. He would have a monitor on him. The court would know where he would be at. There would not be any concern, actually, with him not being at court because you know where he's at all the time. My proposal, with the security on, with the GPS tracking, basically house arrest, it would effectively prove conditions of release can protect the public from risk of physical harm. Given the singular event that Mr. Dimmons is being accused of, it was not like, and I was looking at the different case law when we're talking about danger to the community. Most of the times dealing with a drug dealer and you're in fear of him coming out and still dealing drugs to the community. That's not the issue here. Again, it was a singular event. If there was a concern for public safety, I think I would meet that concern when we would with our stipulation to the house arrest, the prohibition of firearms, and the ankle monitor. I think we could secure that there is no threat to the harm.
Your estimated wait time is 1,267 minutes.
GPS tracking, a 24/7 security guard, money to post bond, that pretty much sums up what the defense is offering. But Melly is also charged with witness tampering, something the judge will likely take into consideration. But the defense had an answer for that too.
That case was very convenient. It was filed while we were pending our last motion for bond, and it does affect the integrity. You recently heard our motions. I was trying to lift the state to argue that C4 motion. The only person my client has been accused of tampering with was Mariah Hamilton. However, going specifically to that statute, it would require Mariah Hamilton was actually summoned to a legal proceeding. That legal proceeding is defined by that statute. The only thing that would be applicable was Mr. Dimmons' trial. Court said it many times. The record is devoid of any proof that Mariah Hamilton was ever under a legal obligation to come to trial. She wasn't. That is the only basis of what the state will argue, is that he's tampering with witnesses. There's been allegations he tampers with this person, he tampers with that person, but there's no proof of it. We deal with, and I was based off the previous motion, not written by the state. Based off the true facts, there's not been any tampering. When we look at these cases, and it was interesting because with both the constitutional right to this bail, it does give that exception, except for people automatically have that right, except if you're charged with a capital crime. So I did some research on that. And the whole basis for that you would not have been given a right, i.e. the right to bail, and then a certain class of people denied bail under that same provision. And they go on further to explain in the history of it, is that initially when somebody was faced with a penalty of life in prison, they feared that that person would abscond or they would flee. Mr. Dimmons knew
Paro connects your business.
he was going to be charged with 2 counts of first-degree murder. At 19, he could have ran, could not, did anything. He did the right thing, Judge. and he turned himself in, I believe February 13, 2019. 6 years ago. Spent 6 years of his birthdays in that jail. The last 3 years that he's spent in that jail, he has been deprived of basic human needs, basically. He's currently housed in a situation that's 23-1.
Counsel, I hate to interrupt you, but there's no evidence of it.
Okay.
The lawyers don't give evidence, so if you want to present some evidence, I read that in your pleadings, but there's nothing in front of me about what his current conditions are in the jail, so I can't consider it.
Okay, good.
You're just saying it, so go ahead.
So, the conditions in the jail aren't good. He's been there 6 years, Judge. The Constitution says everybody gets the presumption of innocence. 6 years. We're going now past 6 years. He has substantial ties to the community. See his mom, his grandma, his sister, his brother, his friends, his grandpa. They're all here supporting him. The special conditions are there, and that's what we get out of the different case law. That proof evidence, great, that's one thing. You go to the second. Are there special conditions that we can put in place to protect those three things? To make sure he's present here. To make sure there's no harm and the
All right, y'all.
integrity
I'm
of
gonna
the
snap that video
judiciary.
down. You know what I'm saying? If y'all go watch it, go on this long
There,
video.
I don't have any
So I
evidence
just
before
did
you.
it a
You're
little
precluded
short
of
or
putting my
whatever, you
witness on.
feel me? But why end up with
He has no
Melly
risk of
if
flight,
he
though, Judge. I don't think
did
there's
it or
anywhere
not,
in this
right?
world that Mr. Demmons could go at this
You
point
know what I'm saying? He don't
without being
spend 6 years
harmed. There
behind the
is no
system.
danger to the
You know what I'm
community.
saying? I
This
bet
was
you
an
see how he looking
insulated
over like he keep chewing
incident
on
that he's
something. I
being
know ain't no
accused of.
gum or nothing. Maybe,
But
you know what I'm
again,
saying?
I
He
believe
and how he
the
keep
special
looking up
conditions that
and
we
looking
put in
down, looking
place
up.
would
You know what I'm
protect the
saying? I
public
don't
from
know if
any risk
he
of harm.
got a little
It
slight
would
mental
also
illness. I
assure
don't
his
know. Maybe he might
presence
be
at
playing
trial.
Cocoa Puff. Who
And
knows?
again,
You feel
he
me?
would be
But my
protecting the
thing is this
integrity
here,
of the,
right? I bet he wish, if he did or
judiciary.
not, I bet he wish he would never try to cook up that murder.
And I
You
believe
feel
he
what I'm
admitted.
saying? I don't know why he cooked up that murder. Maybe he was trying to collect the benefit of them dudes, or maybe he didn't want to pay them dudes. I don't know why he did it. You feel what I'm saying? Maybe he was on something that night. Who knows? You feel what I'm saying? But if he do have a little slight little problem, you know what I'm saying? They not gonna put him out there in the streets because they figure he might do something like that again. You feel what I'm saying? Because they wondering why he did it. You feel what I'm saying? But he keep claiming he ain't did it. So to me, it's allegedly. You feel what I'm saying? Until proven innocent, proven guilty. You feel what I'm saying? So, you know what I'm saying? It's gonna be up to God, man, to let this dude get back out here. But if he ever decide to win that case, I hope he don't get out making the rap songs and all that. Come to tell you something. A lot of these rappers do that. It never fail. You feel what I'm saying? So they make it hard for the next person. Not even more just a rapper. They make it hard for the next person. Because these rappers, when they get out, they brag about who they smoke or who they smoking on. You feel what I'm saying? So, to each and all, man. You know what I'm saying, man? Them people don't want to let him out. You see, they got a courtroom full of these people and the other family. Remember, they don't want to let that dude get out. They don't want him to get out. They don't want to grant him no bond. You know what I'm saying? So, they got a funny feeling. You know what I'm saying? But I'm not going to speak on that. You feel what I'm saying? They family know what's going on. The one that who he took both of their lives. You feel what I'm saying? But at the same time, where that other dude at? Why he ain't on trial? Did he tuck his bid? Because I try to see, they keep posting YNW Melly, but what about the other dude with him? You feel what I'm saying? 'Cause I remember he had got on the bond and he had got locked back up. I don't know, my good people, you know what I'm saying? But anyway, my good people, y'all call me, let me know how y'all feel. So on this note, my good people, I'm gonna scratch that, you know what I'm saying? But y'all know what to do, you know what I'm saying? Like, share, and comment. Smash that doorbell for me, baby, you heard me? Keep God first, baby, over everything. So on this note, my good people, we gone.